You're watching The Legal Breakdown. So, Glenn, the breaking news today is that Judge Merchan has opted to delay Donald Trump's sentencing from July 11th until, at the earliest, September 18th. And this is in light of the Supreme Court's immunity decision. Does the fact that he's delaying sentencing suggest that there is some merit to this idea that Donald Trump could be let off in light of the Supreme Court's decision?
Absolutely not. It's the prudent thing to do. Listen, a brand new Supreme Court opinion was just handed down. Frankly, I was a prosecutor for 30 years. I can't make heads or tails of it. You know, it talks about immunity. It talks about how Judge Chutkan, once she gets the case returned to her, should have all kinds of hearings to figure out if things are official acts, not official acts. Do they fall within a president's core constitutional powers? The whole thing is extremely confusing, and this will be a maiden legal voyage for Judge Chutkan, who's a federal court judge presiding over the case in which the Supreme Court just issued this opinion. She's got to figure out how to conduct one of these hearings. So Judge Merchan's case is a state court case. You would think, well, that's not really even affected by federal law, is it? And the answer is generally no. But because they handed down this sweeping pronouncement about, absolute presidential immunity or presumptive presidential immunity, and they also set out how some statements that a president makes might not be admissible against him at trial. Of course, all of this is kind of like hindsight because the New York trial has already concluded, at least a trial on the merits, and we were just waiting for Donald Trump to be sentenced on July 11th. But this throws a monkey wrench into it. So here's what Judge Merchan is going to have to do. He has already said he will accept briefs from the parties. Donald Trump's lawyers said they wanted to submit their brief on July 10th. Alvin Bragg's prosecutors said they want to file their opposition, and they've already previewed where they're going. They want to file their opposition on July 24th, and they said, but be forewarned, Judge, none of this impacts the conviction that was entered against Donald Trump, the jury's 34 guilty verdicts on all felony counts. But what Judge Merchan is going to have to do is look at this new Supreme Court opinion, try to glean if any of the statements that were introduced as evidence in the New York trial might potentially run afoul of what the Supreme Court just said cannot be used against a president or a former president because he enjoys immunity not only for his conduct, but even the statements he made in furtherance of immunized conduct. Those statements can't be introduced either. So Judge Merchan's going to have to go through the exercise of reviewing the statements that were admitted and trying to decide, are they the kind of statements that the Supreme Court is now prohibiting? And then we can talk about what the possible outcomes are, depending on which analytical road Judge Merchan ends up going down during the course of the hearing.
Glenn, I know the question that everybody's asking right now is, this Supreme Court decision is regarding presidential immunity. The case in question here was from when Donald Trump was a candidate. He was literally trying to secrete damaging information that he thought would damage him in the election to become president. So how could any of this apply to the Supreme Court ruling that was just handed down?
Yeah, great question. All of Donald Trump's conduct and statements when he was a candidate, in other words, when he was entering into this conspiracy with his former lawyer and fixer, Michael Cohen, to not only make these hush money payments to Stormy Daniels, but to falsify business records to cover them up, all to try to steal the 2016 presidential election. All of those statements and all of the conduct that predates the time he was actually sworn in as president, those are bulletproof. All of that evidence is completely unimpacted by this Supreme Court ruling. That's the good news. And that's why at the end of the day, I think the prosecutors will win this issue and they'll win it handily. But here's the thing. After Donald Trump was sworn in as president, remember how he was actually writing reimbursement checks to Michael Cohen out of the Oval Office. So what does that tell us? He was engaged in some conduct. And indeed, we'll talk in a minute about how he was making some statements pertaining to the Stormy Daniels affair, pun intended. while he was president. So, and some of those statements and tweets and posts were introduced as evidence against him. And the Supreme Court said, if a president makes statements that are part of his official duties, well then, those statements shouldn't be admitted as evidence against him. So we've got a couple of bridges to cross here if Donald Trump is going to succeed on this motion. First of all, I maintain all of this is private conduct, non-official duties of Donald Trump. Had nothing to do with his presidency. First, it was criminal conduct while a candidate, and then it was conduct that continued to kind of complete that crime with the reimbursement payments going to Michael Cohen, because Michael Cohen is the one who actually shelled out the money to Stormy Daniels for Donald Trump's benefit. So I would argue that even the reimbursement checks are purely private conduct, not official conduct. Therefore, the Supreme Court opinion does not protect Donald Trump at all, doesn't give him any relief, and doesn't give him a vehicle to attack his conviction. However, I think the tougher question, ultimately one that I think the prosecutors will prevail on at the end of the day, is, well, what about all these statements? When the president is making statements sort of defending himself against these scurrilous allegations by Stormy Daniels, which proved to be true at the end of the day, doesn't a president have some leeway to sort of make these public statements and defend himself? And Brian, here is where I want to turn to the Supreme Court opinion, specifically what they say about presidential statements and whether those statements can ever be admitted as evidence against a former president in a criminal trial. Here's what they say. They say that some of Trump's alleged conduct, this is in the case involving his attempt to steal the 2020 presidential election, but the same principle applies here. Some of his conduct consists of his communications in the form of tweets and public addresses. You're going to love this. The president possesses extraordinary power to speak to his fellow citizens on their behalf and will frequently speak, wait, it gets better, Brian, will frequently speak publicly about a vast array of activities that touch on nearly every aspect of American life. Now, remember, we're talking about hush money payments to a porn star to cheat in a presidential election. We'll come back to that. Indeed, a long recognized aspect of presidential power is using the office's bully pulpit to persuade Americans, including by speaking forcefully or critically in ways the president believes would advance the public interest. He's even
talk about advancing the public interest. Nothing to advance the public interest more than defending yourself against allegations that you sexually assaulted somebody and then hid that to help yourself win an election.
I had you at advance the public interest, I can tell. All right, now and I'll just finish it up. He's even expected to comment on those matters of public concern that may not directly implicate the activities of the federal government. For instance, to comfort the nation in the wake of an emergency or tragedy. And for these reasons, most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities and therefore privileged, and those statements can't be admitted against him in a criminal trial. Of what I just read, does any of that come within 100 miles of the statements Donald Trump was making, lying about paying off a porn star to try to steal an American election? The answer is clearly no. And that's why, in my opinion, when Judge Merchan digs down and litigates this motion, he will make what I believe will be bulletproof findings that, listen, I took the Supreme Court's recent ruling and admonitions into account, and I find that there were no protected statements introduced as evidence in this trial in New York against Donald Trump. Therefore, his conviction is entirely unaffected. Let's go to sentencing. That's the way I anticipate this will play out.
Gaming this out for a moment, obviously the answer to your hypothetical question is no, not on this planet, not in a million years. But that doesn't mean that Donald Trump is still not going to try to appeal this thing, to jump from the state court system into the federal court system, and eventually get this thing in front of the very Supreme Court that bent over backwards to imbue him with these vast presidential powers in the first place. And obviously, if it gets in front of the Supreme Court in that sense, you know, all bets are off in terms of what Clarence Thomas and Samuel Alito and the other three justices who Donald Trump himself appointed are going to say when it comes to this question, and they may very well be sympathetic to him. So is there any worry that if this case does get appealed and ends up in front of these very Supreme Court justices, that they won't interpret that exactly in the way that it shouldn't be interpreted?
When you ask me the question, is there any worry? The answer is almost always going to be yes.
Yeah,
because the Supreme Court does Donald Trump's bidding. I would say they're in the tank for Donald Trump, and they're not honest brokers of the law. They proved that over and over again. They proved it by keeping Donald Trump an adjudicated insurrectionist on the presidential ballot, even though the 14th Amendment says the absolute text, the plain language says, if you took an oath to support the Constitution and you engaged in insurrection, you are ineligible. The Supreme Court just brushed that expressed language aside, textualists that they are, of course. And then they realized Donald Trump was indicted for, among other things, obstructing an official congressional proceeding. So, of course, they said, we're just going to throw that law out, notwithstanding the plain language of the law. They did Donald Trump another enormous favor, and now they just bestowed upon him something no president has ever had, and something that Chief Justice Roberts himself previously said does not exist: absolute presidential immunity. So, might they be willing to take up and review what happened in a state court case where they really have no purview over state court cases, with very limited exceptions? Nevertheless, will they brush aside all law, all procedure, all precedent, and accept review of it only to try to unravel Donald Trump's New York conviction? The answer is that is a possibility. I don't think it's a likelihood, but with this Supreme Court, I would never lay my bet on them doing something that is adverse to the interests of Donald Trump.
So let's game that out further for a second. Let's say that the Supreme Court does find that evidence that was inadmissible was admitted in this case, and that it led to a wrongful conviction here. What happens in that sense? Is a mistrial declared? Do they get to re-prosecute him, but using only evidence that they deem admissible, which is to say evidence that doesn't touch his time while he was actually in office?
Yeah, great question. And the answer is, if we're in the legal right side up, yes, it's remanded for a new trial with instructions that, look, we found this handful of statements inadmissible, they shouldn't have been introduced against him, and they would remand it to the trial court for a new trial. Now, could I see this Supreme Court saying, you know what, we just think the immunity is so broad and there is such a risk that he will not get a fair trial if we remand this, we're just going to terminate it here with prejudice? Again, I think that's unlikely, but in the legal upside down, we never know. But let's game it out a little bit more, because ordinarily what would happen is Donald Trump, once Judge Merchan rejects this attack on the conviction, and I believe he will after a hearing, Donald Trump will be sentenced. He will then appeal to the New York Supreme Court, which is actually the first level of the New York Court of Appeals. Then he will appeal it to the highest court, which is called the New York Court of Appeals. And then he can try to jump into the federal system if he believes there's a significant federal question that needs to be addressed by the Supreme Court. That's the ordinary course of things. All of that would take a very long time. Of course, Donald Trump, I predict, at the earliest opportunity, will simply file something with the United States Supreme Court saying, look, we've got to bypass all of the niceties when it comes to New York procedures, and you need to take this up pronto, because I need another lifeline, if you know what I mean. And goodness knows, they've been throwing him lifeline after lifeline.
Now, let's say that it's working its way through the appeals process. in hopes, as far as Trump is concerned, that it eventually makes its way in front of the Supreme Court. What happens, for example, if Donald Trump is sentenced to 30 days in prison, and yet he's in the process of trying to appeal this thing? Who determines whether that sentence is stayed pending appeal or not?
Yeah, so in the first instance, Judge Merchan, let's go with 30 days. I hope it's more like 6 months, but let's say 30 days. Judge Merchan imposes it. The first question is, does Judge Merchan order him to begin serving it, or does he impose it and then suspend it or stay it during the course of the appeals? Let's assume he says, nope, I'm ordering you to report. Then Donald Trump files an emergency motion with the New York Court of Appeals trying to get them to stay it or stop it from running. Of course, if all else fails, again, he's going to apply to the Supreme Court trying to get them to intervene. They shouldn't. Again, this is a state court sentence of a private citizen for conduct that largely was committed while he was a candidate, not president. But with this Supreme Court, again, all bets are off.
It'll be very interesting to see how quickly they act on it when this is the same Supreme Court who, in Donald Trump's D.C. case, first of all, decided to take up this case in the first place that was properly adjudicated by Judge Shutkin and an appeals court, but then made us wait over 100 days while they sat on it and then released their decision on the very last day of their term. So it'll be, again, very interesting to see how quickly, when Donald Trump is at imminent risk of possibly being locked up, they decide to act versus how they decided to act on this question of presidential immunity that they shouldn't have even touched in the first place.
Yeah, I have every confidence that they will take this at light speed, just the way they did when Donald Trump was adjudicated an insurrectionist in Colorado by both the trial court judge as affirmed by the Colorado Supreme Court. But because the Colorado presidential primary was coming up and the 14th Amendment said Donald Trump can't be on the ballot, boy, they took that up at light speed to make sure Donald Trump would remain on the ballot. The corruption, the favoritism, the bias is just right there out in the open.
Perfectly put. Agree with you on that. With that said, we will, of course, stay on top of any changes we see on this case as well as the other prosecutions that Trump is contending with. For those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. Glenn is on his way up to 1 million subscribers. If you're not yet subscribed, please go ahead and support his channel. And my channel is on its way up to 3 million. So if you're not yet subscribed to this channel and you enjoy our coverage, please make sure to subscribe. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.